Good evening, classmate. Good evening, sir. My name is Rhealyn Isidro from PCBet 22402P. Now, I will tackle about the Article 1332 to Article 1338.
Article 1332. When one of the parties is unable to read, or if the contract is in a language not understood by him, and the mistake or fraud is alleged, the person enforcing the contract must show that the terms thereof have been fully explained to the former.
This article contains two situations in which first, one of the parties is unable to read, second, the contract is in a language not understood by the party.
Remember the general rule for this article. The resumption, one always act with due care and sign with full knowledge and understanding of the content at the same. The person who signed the contract, therefore, bound by all its terms. If later on he claims alleged of fraud or mistake, it is incumbent upon him to prove his allegation. But in this Article 1332, they have a exception. For example, kapag ang isang party ay hindi naiintindihan at nakakapagbasa ng isang contract, and he alleged that the document is fraud and mistake, and the other parties enforcing the contract ay dapat maipaliwanag niya sa another party ang lahat ng terms na ginamit sa contract and ma-prove niya na walang fraud and mistake sa contract. Another example, Glenda is blind, as a contract of mortgage, but actually a deed of sale, and later on he alleged is a fraud or a mistake. Grandma, who enforced the contract, must comply to the Article 1332. If she unable to, then the contract will be annulled. Article 1333. There is no mistake if the party alleging it knew that doubt, contingency, or risk affecting the object of the contract. If the party has the knowledge about the doubt and risk, there is no vitiation of consent, because it assumed that the party was willing to take a risk. He cannot claim mistake or fraud afterwards. B bought a parcel of land from S, who informed him before the contract was perfected that the land was involved in the litigation in which she is the claimant. In this case, the land is recovered later on by C. B cannot allege mistake in this contract because he knew the risk that the land will later on recovered by the C. Article 1334. Mutual error as to the legal effect of an agreement when the real purpose of the party is prestated may vitiate consent. First, discuss the mistake of law. Mistake of law is that which arises from an ignorance of some provision of law, or from an erroneous interpretation of its meaning, or from an erroneous conclusion as to the legal effect on an agreement on the part of the one parties. Effect of mistake of law. As a rule, mistake of law does not invalidate consent because ignorance of law excuses no one from the compliance. The requisite for Article 1334. First, mistake should be mutual error. Second, mistake must be referred to the legal effect agreement. Third, the mistake must prestate the real purpose of the parties. For example, Kuya borrowed to Angela, and Kuya and Angela enter a contract of mortgage in which Kuya mortgaged his land for the debt security, and they enter to the contract of mortgage, but they executed the contract of sale, because they both believe that the mortgage and the sale, they have a same legal effect. Therefore, the consent is vitiated. The remedy for this is annul the contract.